Good afternoon, everyone. Thanks for joining us today. This is Samfiru Tumarkin. It's our live employment law show on Facebook and YouTube. My name is Sandy Chen. I'm an employment lawyer here in Vancouver, British Columbia. I'm here live for the next half an hour. I'm here to answer any and all questions related to the workplace. So if you're dealing with a workplace issue, harassment, or you've been let go, or you're not getting overtime, anything like that, please feel free to ask. I will be, if you type your questions, I will be able to see it on my screen here. I can't see you, but I hope you guys can all see me. So please take advantage. These are issues I deal with on a day-to-day basis. So if you have a question about the workplace, whether it's severance or your boss is not treating you well, or you're not in a good you're in a toxic work environment, or any questions about COVID and the remote workplace, please feel free to ask. I am going to try to get through as many questions as I can. So with that, I see we have our first question. It's from Iona. And so the question is, I'm being harassed at work given a performance improvement plan, which I disagreed. So I found another job. My current employment does not have any notice period to resign. Should I give them notice? If I give my resignation letter, can my employer fire me, and will I get any severance? So I know, good question. First of all, I'm sorry to hear about the harassment at work. I mean, that's obviously illegal, first and foremost. It's the WorkSafe BC can help you if your employer is not doing anything about it, right? You can file a complaint with WorkSafe BC. First step. I mean, I know that you're leaving now, so that might be an irrelevant point. You do have to give notice to resign. I would give 2 or 3 weeks. An employee does have a duty to give reasonable notice. Now, if the harassment is so bad that you have to leave immediately, that's fine, right? But technically at law, you do have to give reasonable notice of resignation. If your employment contract isn't specified, I would give 2 or 3 weeks. If they fire you during the notice period, and you don't have an employment contract, they will have to pay you out the balance of the resignation period. And I'm answering that question with the assumption that you don't have a written employment contract. So your vacation pay, the 3 weeks you have left, you will get paid out. And it's mandated by law, whether you resign or whether you're let go. They do have to pay you out any unused vacation pay. So the 3 weeks that you have left will be paid out at the end. But I would if the harassment is so bad that you can't be around any longer, then that's fine. You don't have to give any notice. Happy to talk to you after about this, and if you have any other questions. But technically at law, you do have to give notice of resignation. So we have another question here from Mandel. The question is, what's the best strategy for dealing with a toxic work environment? That's a very good question that I can give a long answer, a medium answer, or a short answer. So if these types of cases are really difficult to prove, most of the time, it's going to be your word against theirs, right? Your word against your boss or whoever is harassing you. And so it's important to make contemporaneous notes if you're being harassed. So for example, tomorrow, if you're in a toxic work environment, you have to note down the particulars of what's going on at work, right? So just say the date is whatever, July 23rd, 2021. Today, XYZ happened, right? In some situations, I would actually recommend perhaps recording a conversation with whoever's causing the toxic work environment. Because toxic work environment is, for the most part, it's harassment, but it can also be other things, right? Obviously, if you're if you're being disciplined for no good reason, that could cause a toxic work environment. So definitely speak to a lawyer about your situation before you start recording conversations with, secretly. I mean, it's technically not illegal to, so I see the follow-up question, is the recording legal? So it's technically not illegal to record a conversation that you're part of, right? So if me and another person are talking, I can record that conversation without their knowledge. It is definitely illegal to record a conversation that you're not a part of. So I don't know, maybe your supervisor and another employee are having a conversation, and you can't leave your phone in the room and record that conversation because you're not part of that conversation. But in some situations, I mean, especially in these toxic work environment cases, it's sometimes definitely, I would recommend recording if that's the only way you're going to get evidence. Whether that recording is admissible or not in court is a different question, but it is not illegal to record a conversation that you're part of. But definitely talk to a lawyer before you do that, because sometimes it can backfire against you. And so I see a question. Are we live? Yes, Northern Mustangs, we are live. So I got another question from Hannah AF. I think your question got cut off. All I see is I got promoted to A. So if you want to try retyping it in there, I'll try to answer it. Iona asks, my husband's employer recently came and asked him what he was doing for 12 to 1:30. Is that harassment? That doesn't sound like harassment to me. I guess I need more details. What was the context of them asking what your husband was doing? I mean, are they insinuating some sort of wrongdoing on the part of your husband, or are they just asking him, are you taking too long of a break, or but simply asking what you're doing from time X to time Y is probably not harassment. And I see you've asked my direct number. So my information should be on the screen, hopefully, for you guys there. If you go to employmentlawyer.ca, you can find my profile, and my direct number is on there. So you can contact me that way. My email should be on the website as well. So please feel free to shoot me an email, and we can definitely chat further. Okay, so Northern Mustang asks, what if my employer pushes a document on me to sign? And sorry, Northern Mustangs, your question just went off my screen here, so I'll get back to you. But it just went off my screen. Let me just see if I can get your question back. Okay. So guys, in the meantime, I'll try to answer Hannah AF's question while I try to get the other question back here. My mother got promoted to a higher position with higher pay but low job security. That meant she could go with 30 days notice after 14 years of working there. After she was not aware of the job security, after she was promoted, her responsibilities reduced, and eventually she was let go. She believes this has been strategically planned. She's also experienced harassment. So Hannah, if there's a contract that says 30 days notice, please contact me afterwards. That's probably not going to be enforced by a judge in BC. I'm talking about BC. Other provinces are different. But if your mom's in BC and the contract says we can let you go with 30 days notice, I can, no guarantees, but I'm fairly confident that that's not going to be enforced by a judge, and she should get a lot more severance than the 30 days notice that she got. If she was there 14 years, and assuming she's, a bit older in her 50s or 40s or 60s or whatever, she could probably get, close to a year or maybe even more than a year's pay as severance. Especially, and sorry, your question about the harassment got cut off there, so I can't really read the second part. So the harassment obviously adds to the case because it opens the door to additional damages. So I'm just going to go back to the previous question. What if my employer pushes the document on me to sign? I did not sign. Does silence mean acceptance? No. There's a very old English case which is from the 1800s where that issue was explored. I'm gonna say to you, no. In the employment context, silence cannot be accepted. So you're fine. If the only thing to watch out for in that particular situation is if the employer says, here are the new terms, and you don't object, right? And they unilaterally change your territory and compensation, and you don't say anything, that could be problematic because you could be deemed to have acquiesced to that change. So if they give you a document, you don't sign it, they don't change it, you don't change the terms, you're fine. If they give you a document and you don't sign it, but then they do it anyways, and then you don't say anything for a few months, that's problematic. So I think in your situation, you should definitely, especially if they've already changed your territory and compensation, object, right? Send something in writing saying, hey, I'm not accepting this change. And that way you have it on the record that you're not accepting it. So I see we have a question from Fredette. And I'm just going to ask my colleague here to send me the full question so that I can read it. Okay, so for that, I will get right back to you. Sorry, your question just got cut off, so I'm going to try to see if I can get the full excerpt. But I'll move on to DB12 for now. So DB12 asks, my employer won't accommodate my doctor's note for hours and shifts per week. They are claiming undue hardship concerning my doctor hours suggested as unreasonable. Can they let me go? They want me to work a minimum hours per week or additional days to make up the hours instead. So the question to TB12, the question of undue hardship is always dependent on reasonableness. It is very difficult to assess, just here while we're on this live show. I can tell you that the bigger the employer, the bigger the company, the harder it is for them to say undue hardship, right? If you're working for a small mom and pop shop, there's 3 employees, perhaps that's reasonable, right? But if you're working for a multinational corporation that has tens of thousands of employees, that's not going to fly, right? I mean, if your doctor says you can only work X amount of hours and X amount of shifts, that's a big company is not going to be able to say that's undue hardship. I guess the other question is this a permanent thing, right? Are you going to be, is that just a gradual, it's a temporary decrease in your hours and shifts, or is it permanent? That's also plays a part in the analysis. So DB12, it's a large company. I mean, yeah. So I guess the question for you is how long, are you part of a gradual return to work plan, or is it a permanent, your hours will have to be reduced? I'll tell you now, if it's a large company and they have big operations here in BC, it's going to be tough for them to argue undue hardship because of that. So back to Fredette's question. So Dan, TB12, I just got your note that it was permanent. Let's chat after this. Shoot me an email or give me a call. But just by that one fact that it's a large company, it's, if you, and depending on your job too, right? Certain jobs you have to be able to work certain hours. So it's a very contextual analysis. I think it'll be tough for me to give you a solid answer here. So from Fredette, I recently asked on here about working on a contract through my work placement company. My contract was cut short a week and a half, and Lawyer said I could get paid for the remaining. I could get paid for the week and a half remaining. I cannot afford a lawyer. Can I write and request pay? Absolutely. Yeah, you don't need I mean, listen, it always, obviously, there's more weight coming from a lawyer. You can absolutely just write to the company yourself and request pay. The other thing, Fredette, assuming you're in BC, is that you should file a complaint with the Employment Standards Board, right? Because if your contract was cut short, they still, I mean, assuming you're an employee, they still owe you termination pay. But I mean, there's some, if you're through a work placement company, there's a question of who has to pay you that. But technically, you know, if it's a contract and you said they would give you X amount of hours and they cut it short, the balance is owed. Okay, sorry for that. I can't. Unfortunately, I can't. I know you're in Alberta, so I know about some about Alberta law. I'm not licensed there, so I'm sorry I can't answer your question. But I would contact the Employment Standards Board in Alberta and see what they can do. Alternatively, this sounds like a civil action. You can start in small claims court. But I agree with you. If it's just a week and a half, I don't know how much you're making, but it sounds like if you pay a lawyer, it's going to eat into the entire amount, right? So TB12, you can send email privately. I mean, you go to employmentlawyer.ca, click on my profile, and my email on there is sandy.chen@stlawyers.ca. So I see I missed a few questions here. I'll see if I can pull them up again. And I do apologize, but the text box here is limiting me to just the first few text boxes on my screen here. Okay, so I see we have another question here. No, I think so. Northern Mustangs, I think I missed your question below. If you want to resend that, I'm happy to try to answer it here, but it's too far down my screen now, so I can't see it anymore. But if you want to resend that. Okay, hopefully I've answered all the questions. Sorry, I'm just seeing if there's another question here. Okay, guys, so if there's any more questions, please just shoot them up on the screen here. I can't see the ones below a certain amount of, or a certain box here. Oh, there we go, Northern Mustangs, okay. A recent written filed harassment claim is being dealt with. What would the expectations be? Issue was a colleague email and continuous issues. HR is involved, and SPV seems to be dismissing the concern. So if you file the harassment complaint, the company has an obligation to investigate, and one of two things will happen. If they come and find it's unsubstantiated, then you need to take it to the next step, right? You need to ask why it's not substantiated. And if the evidence was overwhelming, then you could have what's called a constructive dismissal claim, which means they're not dealing with your harassment complaints, and therefore you can claim you could possibly claim it's a toxic work environment and claim for severance. They could come back and say the complaint is substantiated, which means they would have to take action against whoever, against the person, the harasser, right? Those cases, Northern Mustangs, are always so fact specific. But I think I can reasonably tell you that you can expect the company should investigate it thoroughly and come to determination as to whether the harassment happened, right? The biggest issue, I think, for employees is what happens if they say that it's not substantiated, and that's where it becomes a bit tricky, because if the complaint is so clear and they just say no, it never happened, that's when you need to think about claiming for perhaps what's called a constructive dismissal claim. Okay, so Hannah AF has another question here. My mother says the contract's part of the 30 days notice, part of the collective agreement she signed. So Hannah, that's one. I'm glad you raised that point, because I should have prefaced my answer with a caveat. If you're unionized, Severance works differently. Okay, if your mom's part of the union, I can't help her even if I wanted to, because it has to be the union lawyers that help her. And I mean, the whole point of being in a union is job protection. The 30 days notice sounds odd to me, because the whole point of being in a union is they can't just let you go unless it's for very specific reasons, right? If it's a collective agreement, tell your mom to talk to the union representative. They should be able to tell her if the company was allowed to do this or not. Typically, the collective agreements will say you can't let someone go unless you have just cause, or if the employer is like shutting down or something like that. So talk to the union rep. I'm sorry, but I can't even help your mom if I wanted to, because she's part of the union. And I'll tell you that severance works very, very differently when you're part of a union. So Vince Lonsdale asks, our company falls under a landscape company, so we don't get any overtime, even though we work in a retail. Vince, which province are you in? Because I mean, I'm not sure that landscaping employees fall out of the overtime entitlement to under the BC regulations. So if you could let me know what province you're in, I might be able to answer that question for you. Okay, so we've got a question from Drina Anderson. So Vince, you're from Ontario. I'm not licensed in Ontario, unfortunately. I will tell you that I don't think landscapers are disentitled to overtime in Ontario. There's very few exceptions in general in Canada to overtime, and that's professionals such as lawyers or doctors. I would look into that, Vince, because that doesn't sound right to me. But unfortunately, I'm not licensed in Ontario, so I can't answer that question for you. But definitely look into that, and we do have Ontario lawyers at our firm that will be able to answer. So I'm sorry I wasn't more help for you there. So Drina Anderson asks, what is just cause dismissal in BC? And Vince, just so you know, someone will be on tomorrow from Ontario at 1:30 for questions as well. So maybe attend that session. One of my colleagues from Ontario will be on to answer questions. So I would shoot that question by my colleague. Drina Anderson's question is, what is just cause dismissal in BC? So I'll try to answer that in a way that isn't too convoluted. So there's two types of dismissals in Canada, let's call it, for non-unionized employees. You can let someone go without cause, or you can let someone go for cause. So without cause just means you didn't do anything wrong. The company is just saying, whatever business reasons, whatever reason they want, they don't like the color of your shirts, they're gonna let you go, right? And they have to pay you severance. And severance could be a week, or it could be up to 2 years' pay. When a company says they have just cause, that means they're saying, we're not going to pay you any severance because you did something wrong, right? And Mr. Smith employee, you've done something wrong. We're going to pay you zero severance. And those cases are often litigated to trial, right? Because just because the employer says they have cause doesn't mean that they do, right? A judge very often disagrees, right? So X corporation says, well, Mr. Smith, you were late to work on, yesterday, and so we're going to fire you for cause. That's not going to fly in front of a judge, right? A judge is going to say that's not cause. So that's all the employer is saying when they say, if they say in the termination letter, or if you get called into HR and they say, we have just cause for your dismissal, what they're saying is, employee, you did something wrong. You're not getting any severance, and you're terminated effective immediately. There's a case from Ontario from a few years back where just to show you, Drina, how high the standard is for an employer to prove cause. One employee in Ontario, I think, punched someone in the face at work, and I punched in the nose, I think. And this was an intentional, heat of the moment, obviously. But and the employer said, we're going to let you go for cause because you punched someone in the face at work. That case got litigated to trial, and the judge said to the employer, you don't have cause. Because what the judge said was, this guy's been with you for 14 years. He's been a stellar employee. He's never had any other disciplinary issues. This punch in the face was a heat of the moment thing. And so, you're going to have to pay severance to the employee. And so in that case, I think the judge awarded, I forget the exact dollar amount, but it was quite a bit of money to the employee, because the judge disagreed with the employer that it had cause. So I hope that helps with, with kind of understanding what just cause is. Whenever you've been let go for just cause, I would always seek some legal advice, because a lot of times, and I'm not saying most employers are bad or anything like that. I'm just saying a lot of times when an employer says cause, just cause, it's not necessarily the case. And I would say more often than not, they're probably wrong, because the standard is very high. Judges have called termination for cause basically the capital punishment of employment law. And so if you want to impose the capital punishment of employment law on someone, it takes a lot, right? If you're late once or twice, it's not going to fly. So in terms of what you can do, if you're terminated, Drina, it's the action's called a wrongful dismissal action, right? And I'm sure if you Google it, there'll be a lot of, articles and blogs written on it. But what you would sue the employer for is called wrongful dismissal. And essentially what you're suing for is the severance money, right? Because when people are let go, it's very hard for someone to find a job, that quickly. So severance is meant as a buffer between jobs. Sometimes it doesn't cover the whole period. Sometimes it does. But if your employer lets you go, regardless of whether they had cause or not, I would seek legal advice to kind of determine if and how much of a severance package you're entitled to. If you've been with a company 30 years and you're in your 60s, you could be, you should be getting at least 18 months to 2 years pay as severance, I would say. A lot of that is because our courts recognize it's for some people, it's tough to find new employment right away. And in the meantime, the severance is supposed to be kind of your income as a buffer, right? I know there's EI and other government programs you could get, but EI is $500 a week. I think capped at $500 a week, so it's not much. So so in case anybody's wondering, if you've been let go, you could potentially sue your employer for what's called a wrongful dismissal, and that's for severance money. And sometimes if the employer treats an employee so bad, right? Like let's say they make up these allegations against the employee, and then it's proven to be completely false, and then they have security escort someone out on the day of their termination, and it's public and everybody sees it. If the conduct by the employer is so bad, the judge might actually award extra damages, right? Those are called mental distress, or what we like to call aggravated and punitive damages. So just be aware of that. I mean, employers, they do have a lot of power for employees, but our court system is here for a reason, to try to to kind of keep that kind of behavior in check and make sure that employees are being treated fairly, and that appropriate severance pay is obviously paid upon termination. So guys, I think we're out of time here. I'm sorry if I couldn't get to everyone's questions today. As I said before, my colleague from Ontario will be here tomorrow. And I will be here every 2 weeks, every 3 weeks. So, we'll chat again soon, but thanks everyone for being here. And, Everybody keep safe and have a good weekend.